All right, boys and girls. So the other day, after the New York State decision was released, GPAC, the Gun Violence Prevention PAC, sent out a release about the New York State decision. Quoting from that release, GPAC reacts to Supreme Court ruling that permits handguns in public spaces. Chicago. The Gun Violence Prevention PAC, GPAC, released the following statement in response to this morning's ruling by the U.S. Supreme Court that permits handguns in public spaces at the cost of public safety. The Supreme Court decision in the New York case, does not threaten any of our Illinois gun laws. It explicitly affirms the constitutionality of concealed carry permit laws like the one Illinois adopted in 2013, said Kathleen Sansis, President and CEO of the Gun Violence Prevention PAC. The ruling also recognizes that the state may adopt a variety of regulations on who may own or carry guns and the types of guns that are lawful. We will continue to work for the effective enforcement of our existing laws and for the new common sense laws that are constitutional. I don't think she's reading the same decision that I read. Our Attorney General went on to issue a statement. Attorney General Kwame Raoul today issued the following statement regarding U.S. Supreme Court decision in New York State Rifle and Pistol Association, Inc. v. Bruin. Today's decision, striking down New York's statutory scheme, does not affect Illinois' concealed carry laws or other gun safety measures and the steps that we have taken as an office to prevent gun violence and build safe communities remain preserved. In fact, the Supreme Court's opinion cites Illinois as being among those states whose laws are not affected by the decision. I'm not even going to read the rest of the decision of his statement. I don't know what Supreme Court decision they read because they clearly didn't read New York State Rifle and Pistol Association. I'm going to go in here. I'm going to drop in. So let's pull up the footnote on page 30. Footnote number 9. This is going to get a lot of play. A lot of people have been paying attention to this. To be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes, under which a general desire for self-defense is sufficient to obtain a permit. Because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment right to public carry. Rather, it appears that these shall issue regimes, which often require applicants to undergo a background check or pass a firearms safety course, are designed to ensure only that those bearing arms in the jurisdiction are in fact law-abiding responsible citizens, and they likewise appear to contain only narrow, objective, and definite standards guiding licensing officials, rather than requiring the appraisal of facts, the exercise of judgment, and the formation of an opinion. Features that typify proper cause standards like New York's. That said, because any permitting scheme can be put towards abusive ends, we do not rule out constitutional challenges to shall issue regimes, where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. Imagine that. I've been seeing some stuff here where anti-gunners are already running to Roberts and Kavanaugh's concurrence, saying that that's those two guys, since they take it from 6-3 now down to only 4 votes, that becomes, the true opinion. that is, that's it. But, here, unlike New York's may issue regime, those shall issue regimes do not grant open-ended discretion to licensing officials and do not require the showing of some special need apart from self-defense. As petitioners acknowledge, shall issue licensing regimes are constitutionally permissible, subject, of course, to an as-applied challenge if a shall issue licensing regime does not operate in that manner in practice. Going forward, therefore, 43 states that employ objective shall issue licensing regimes for carrying handguns for self-defense may continue to do so. Likewise, the 6 states, including New York, potentially affected by today's decision, may continue to require licenses for carrying handguns for self-defense so long as those states employ objective licensing requirements like those used by the 43 shall issue states. So, going back to the Attorney General's comment, in fact, the Supreme Court opinion cites Illinois as being among those states whose laws are not affected by the decision. Wrong, Mr. Attorney General. It is just the opposite. And we'll go back to Ms. Santz's affirms the constitutionality of concealed carry permit laws like the one Illinois adopted in 23. No. Our shall issue portion of the law is unaffected. However, Illinois is not a complete shall issue law. We got wrangled into some exemptions in there, and one of them is found in Section 15. The statute is 430 ILCS 66 and subsection 15. Objections by law enforcement agencies. Any law enforcement agency may submit an objection to a licensed applicant based upon a reasonable suspicion that the applicant is a danger to himself or herself or others or a threat to public safety. There's no standards with these. The objection shall be made by the chief law enforcement officer of the law enforcement agency or his or her designee and must include any information relevant to the objection. If a law enforcement agency submits an objection within 30 days after the entry of an applicant into the database, the Illinois State Police shall submit the objection and all information available to the board under state and federal law related to the application to the board within 10 days of completing all necessary background checks. There is nothing in that is objective. It is all subjective. And it requires the exact things that the court said you can't do. It's it there in footnote 9 where it talks about appraisal of facts, the exercise of judgment, and the formation of opinion. That's exactly what the first part of Section 15 requires. No ifs, ands, or buts about it. And it has been abused. We've had cases where people have waited over a year to get an answer from the Concealed Carry Review Board. What did footnote 9 say? For example, lengthy wait times in processing license applications. Hey, guess what? I think a year is excessive. I think 90 days is excessive. Well, let's go back to Section 15. If an applicant has 5 or more arrests for any reason that have been entered into the criminal history records information system within the 7 years preceding the date of application for a license, or has 3 or more arrests within 7 years preceding the date of application for a licensee for any combination of gang-related offenses, the state police shall object and submit the applicant's arrest record to the extent the board is allowed to receive that information under state and federal law. The board, for the purpose of this subsection, gang-related offenses are defined as yada, yada, yada. Okay? So then, the referral, subsection C, the referral of the objection under the section of the board shall toll the 90-day period for the Illinois State Police to issue or deny the applicant a license. There's no time period specified. So, you have three things there, and none of it contains any objective standards. Just X number of arrests for whatever reason. Throw you into the hoosegow. They get, and here's the thing. You could have somebody in Cook County, somebody in Whiteside County. Same age, same background, same 5 arrests, same charges. Tom Dart in Cook County objects. Sheriff in Whiteside County doesn't. There's no standard here. So I think the LE objections are definitely on the chopping block, and it's definitely going to affect Illinois' concealed carry law. We now scale down to Section 60. Remember that little thing in footnote 9 about fees? So you've got a $150 fee for our carry license for residents, $300 for non-residents. And then you get into if you have to have a change of address or something, that's $75. I think all of those are suspect to challenge. So again, Ms. Sanses, you got it wrong. Attorney General Raoul, you got it wrong. And then another big one is prohibited places. So there was a fair amount of talk in New York about sensitive places. Illinois has 23. Now, when I review these, a couple of things. I think we have to ask ourselves, is the juice worth the squeeze? There are places, there's 10 casinos in the state of Illinois? Okay. I mean, it's not like we're Vegas. Let the guys in Nevada go take that challenge up. And if they win it, good on them. But I have a feeling that almost all 10 of the casinos in Illinois, they're posted today because they're required to post. But if that went away, I think they're going to be posted anyways just because that's what they're going to do. I think stadiums and the like are going to get posted just because. So is it worth taking on Soldiers Field? Is it worth taking on Wrigley Field or Kaminsky? I just don't think the juice is worth the squeeze on those. However, I think there are some that will have some in there. Number one, any building, real property, and parking area under the control of a public or private elementary or secondary school. I think that private schools there, I think that has a chance and an opening to consider, especially if you have a place that has a church. They want people to carry on the weekends during service, but they have a school on premises. That's never been fully flushed out. Any building, real property, and parking area under the control of a preschool or child care facility. There are some people who run home daycare. I think that is out. I think this part here, some of the national chains are not going to want, they're going to keep posted. So again, I don't know that should be our first challenge, but any building, parking area under the portion under control of the executive or legislative branch, their governmental offices is going to be a tough nut to crack. But I think there's going to be some pushback, and not every governmental office is a sensitive place. Obviously, number 4, courts, that's out. 5, any building under the control of local government. I think some of that may, some of it may be ripe for a challenge, but again, in the short term, nah. Any building or real property in control of an adult or juvenile detention, prisons, jails, whatever. Nope, it's not going to change. Any building, real property under control of a public or private hospital. There's a lot more hospitals that are casinos, but I'll bet you the people that run most of them are going to post no matter what. So I think that, the juice ain't worth the squeeze. Now this one, 8, any bus, train, or form of transportation paid in whole or part with public funds, any building, real property, and parking area under the control of a public transportation facility paid for. No. I think we win mass transit hands down. They're already fretting this in New York City. I think we win that one hands down. Any building real property and parking under the control of the establishment that serves alcohol on its premises if more than 50% of the established gross receipts. We may win on taverns, but I think our standard is unique that, we kind of have this, you can't be drunk. We've got this is called the restaurant carry. We worked real hard to get that. Don't know if I want to be fighting for taverns right off the bat. But if a couple of tavern owners want to make an argument that they should be allowed to decide for themselves, we do have it's illegal to carry while intoxicated. Any public gathering or special event conducted on property open to the public that requires issuance of a permit from a local government. No. I think we win that one. The parades, all that other stuff, I think we win that one hands down. Any building or real property that is issued to special event retailers, liquor license, it's going to be a coin toss. Any public playground, I think we win that one hands down. Any public park, athletic area, I think we win those hands down. The Cook County Forest Reserve was already dealt with by the courts. Then you've got number 15, clinical medical hospital. 16, any building, real property, or parking under the control of the gaming facility. Again, that's the casinos. I don't think the juice is worth the squeeze. Any stadium, arena, or real property under the control of a collegiate stadium or arena, same thing. Any building, real property, or parking under control of a public library. Now, there is a governmental building that I don't know is a sensitive place. Not at the top of my list, but, it starts whittling that down. Any building, real property, or parking area under control of an airport, any building, real property, or parking under control of an amusement park, again, I don't know. I want to test my holster out on a roller coaster, but any building, real property under control of a zoo or museum. Now, museums, I think for D.C., that's a big issue. I think there's a different issue in D.C. with those. Those also qualify as government buildings. I don't think they're sensitive places per se in that situation. 22, nuclear power facilities. No, that's federal law. 23, any place firearms are prohibited under federal law. I think that federally we're going to get a chance to challenge the parking lot rules at VAs, post offices, and stuff like that. So, that's what I think. So Illinois carry law, we have 4 distinct areas between the non-residents, between the LE objections, between fees, and then sensitive places. I think there are 4 places Illinois' law is out of compliance with the New York State Rifle and Pistol Association decision. So again, I don't know what decision Ms. Sanchez and the Attorney General are reading, because let's go back to the standard that was enumerated in New York. In New York, they said to justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual conduct falls outside the Second Amendment's unqualified command. Unqualified command. Those are some pretty strong words. And I don't think the fees, I don't think the non-resident, how do you have a right that only Illinois residents can enjoy? And if I want to have a carry permit in California, I have to pay their $500 or whatever it is. The other part that they had in the opinion, if the last decade of Second Amendment litigation has taught this court anything, that the federal court's tasked with making such difficult empirical judgments regarding firearm regulations under the banner of intermediate scrutiny often defer to determinations of legislatures. But while that judicial deference to legislative interest balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. It is this balance, struck by traditions of American people, that demand our unqualified deference. 3 statements there. Elevates above all other interests. Demands our unqualified deference, and the Second Amendment's unqualified command. That, in my mind, puts it well above strict scrutiny. And the government has some monstrous hurdles to get over in order. So, I don't know. I keep saying it. I don't know what opinion GPAC and the AG were reading, because I read this and Illinois' got problems. And they can either fix the law, or I'm certain we're going to be taking them to court. And we'll just rub their nose in doo-doo every time we prevail. So, that's it. You guys like it? Hit the like button, hit the subscribe button, share this around on social media to your friends, get us some likes and views. And we're going to keep pumping out this content. So it's been a long day on the dozer out at the club today, but I wanted to get this out because GPAC's just wrong. You're just wrong. And I'll put a C note on it. So, all right, guys. Good night.